And welcome back to Red and Blue. Former President Trump is in New York City and will stay at Trump Tower this evening before heading to the Manhattan Criminal Courthouse Tuesday, where he will surrender and face charges. Sources told CBS News over the weekend Trump will be charged with falsifying business records in the first degree, which is a felony. But as of now, the charge or charges are still under seal. CBS News legal contributor Rebecca Roiphe joins me now. Rebecca, good to see you. Thanks for being here. What else may be in this indictment? We understand there are about 34 charges.
So, Caitlin, thanks for having me on. It's nice to see you. Yeah, so it is reported that there are 34 charges, and we don't know what those charges are. So all of that conversation in the public and the media about what is going on with this in prosecution really won't become clear until we know specifically what those charges involve. So there could be multiple charges for each time there was a falsification of a business record. And there could also be multiple theories because, as we were saying before, when it's a misdemeanor charge, there needs to be a falsification of business records with an intent to defraud. But in order for that to be a felony charge, it would have to be that intent was also to commit or conceal another crime. So it's possible that there are multiple theories about what that crime is or could be that the president was seeking to commit or conceal by falsifying those records having to do with the hush money payments to Stormy Daniels.
Yeah, and as we're all waiting for that, there has been so much attention put on Alvin Bragg, the DA here. Lots of criticism, of course, generated by former President Trump and his allies. But there's also been a question of why taking this case now, why he's moving forward with it. The former U.S. Attorney Preet Bharara was on Face the Nation over the weekend. I want to play a little bit about his thoughts about why Bragg pursued this case, and then we'll talk about it on the other side.
I can't, speculate as to why Cy Vance didn't bring the case, or why my former office didn't bring the case, although there are some reasons to think maybe it was because they were concerned that Michael Cohen had not been fully forthcoming, and they have a policy of not putting on witnesses as cooperating witnesses if they haven't divulged everything about themselves and everyone else. That was a policy that was in place when I was the U.S. attorney. So different policies, different legal considerations may be the reason why there's a divergence, but we don't know for sure.
Rebecca, I'm really curious about your opinion about all of this and why he, may be bringing this case now.
So I agree with Preet that it's impossible to know from our vantage point what happened in those internal discussions, why there was some sort of delay and why it was picked up again. But I will say something about this falsification of business records charge in New York. It's kind of the bread and butter of what the DA's office does. It's the way in which Manhattan prosecutors have historically held those in power, particularly white-collar criminals, responsible for their acts. So it's not an unusual charge, and it's entirely possible that the office just sees this as well within its ambit, exactly the kind of thing that Manhattan does and the kind of prosecutions that Manhattan brings.
That's a really interesting point. And a lot of people have also commented on the notion that this is kind of an untested case, that there's not really a precedent for it. I'm wondering kind of how you think that factors in and what that could imply.
Again, I don't know whether it's unprecedented until I see the actual indictment. Bringing charges under the statute is not at all unprecedented. It's done all the time. And, in cases that seem quite similar to me, but there are some unique challenges that the factual situation, at least insofar as we understand it, involve in terms of, again, what would be that crime that the former president was seeking to commit or conceal. So, I think we need to wait and see about whether or not this is along the lines of what the Manhattan DA's office has done before or something novel. My guess is it's not testing new ground in a case like this, but of course we don't know until we actually see it.
Yeah, absolutely. We don't know until we see it tomorrow for sure. Just hearing from the U.S. attorney, it was interesting. Michael Cohen's name obviously keeps coming up over and over again. I mean, he is the key witness here. Can you kind of remind us about, how much this case really hinges on his testimony?
Well, it really does. But the key question with a cooperator like him is, can you corroborate what he says? Because, in certain ways, it's just so clear from what he has done in the past and the ways in which he has acted and the things he has said about the former president that he may indeed have a motivation to lie here and that he doesn't hesitate about lying in the past. But that kind of thing is not as much of a hurdle as you might think for prosecutors, because all you need to do is convince the jury is that he's telling the truth about this one thing. And in order to do that, you need to corroborate a substantial amount of what he's saying, and also kind of convey to the jury that this story is the more plausible of this. No other story really makes sense. And in this case, it is kind of hard to imagine what he would be doing, characterizing these payments as attorney's fees. Why would he be structuring it? In other words, why would he be paying it in increments and trying to make it look different than what it is if it weren't for the fact that he's trying to do something illicit? And if that's the more plausible story, it is, it's not that hard for jurors to think, well, this is a lying person who's not lying in this particular moment. So again, I think Michael Cohen as your key central witness is not ideal, but I also think that there are ways to get around the problems that it poses.
Rebecca Roiphe, we are so grateful for your legal expertise, and we will find out more tomorrow and hopefully talk to you again about all of this when we know more. But thank you so much for your time. We appreciate it.
Thank you.